What's the tea? Welcome everyone to Trust and Trade, your weekly glimpse into hot topics in the world of antitrust and consumer protection.
Hi everyone, and welcome to the latest episode of Trust and Trade, the ABA podcast that gives a glimpse into hot topics in antitrust and consumer protection. My name is Jenn Mellott, and I'm a partner in the antitrust group at Freshfields, Bruckhaus, Deringer, where I split my time between DC and Brussels and work on a range of US, EU, and UK antitrust matters. Today I'm here to interview Owen Kendler, who almost needs no introduction, but let me give you the highlights anyway. Since January 2021, Owen has served as the chief of the new Financial Services, FinTech, and Banking section at the Antitrust Division. Before this, he's had a long career at the Antitrust Division, first as a trial attorney, then serving as counsel to the Assistant Attorney General, then as an assistant chief and eventually a chief of the Media, Entertainment, and Professional Services section. Hi, Owen. Really great to have you here for the podcast today.
All right. Well, thank you for having me. I do want to, before we get going, just to say the views I'm going to express today are my own and do not necessarily reflect the views of the DOJ. But other than that, glad to be here.
Great. Well, maybe let's start with your most recent role as the chief of the new Financial Services, FinTech, and Banking section. And this is a new division that was just created at the beginning of this year. So for people who are maybe less familiar, can you talk a little bit about how this differs from the prior setup for financial and fintech acquisitions and why the division decided to consolidate those within a new section?
Sure. I'll go back kind of through the history. I mean, whenever you allocate commodities at one point in time, over time, the differences and between those allocations will start to blur. I mean, the U.S. economy is dynamic, and when you put something in place and you think these are dividing lines 20 years down the road, it doesn't look so clear-cut. And that's kind of what happened at the division, not just for the financial commodities, but other commodities. So previously, we had credit cards, actually. So we actually had a piece of the financial portfolio. Our section years ago in the late 90s and early noughts did U.S. versus Visa, and of course we did the U.S. versus Amex case. But we also had other commodities, specifically commodities that were advertising-based, so newspapers, radio, broadcast television, and a whole host of other things, to be honest. But the financial services were divided amongst 3 or 4 divisions sections in the division. So we had credit cards, another section had debit cards, another section had the financial platform portfolio, SEC-focused things, trading exchanges, and another section had banking, traditional banking, like retail outlets. All those have now been brought together into the new FFB section, the Financial Services, FinTech, and Banking. It's actually a really good thing. It used to be that we had various experts in different sections that were slightly siloed, although not completely, and by bringing them together, they can share knowledge across different financial services and products, learn from each other, do investigations together, and it just makes for more efficient investigations.
So that's really interesting. I mean, it sounds like, previously you had bits of the financial piece, some of it sat elsewhere. You also had media and telecom. Can you tell us a bit about why you were interested in taking this position as the chief of the new section, and how have you found it in its initial year?
So I actually think it's been great. The division, everything is about change. I mean, I actually don't see it as all that much of a change in my own career because I've bounced around so much, and many attorneys at the division bounce around between commodities. And of course, our economists are always changing commodities. So at the division, not only is each section kind of, in a sense, a hodgepodge of commodities, despite what the title may say on their section name, but attorneys detail around the building as well to work on large investigations, things in litigation. So everyone is kind of jumping between commodities. So this commodity shuffle is not surprising or unique, but it's also exciting because we do get to play with a bunch of new commodities and learn from experts within the division, learn from experts in our sister agencies, and it's just been exciting.
Yeah, I think that probably resonates with everyone listening who decided to become a competition lawyer at some point for sort of that same reason. And, look, I understand that your group does still have a hand in some of the media and telecoms work, and we're recording this on November 4th, so I would be remiss if I didn't ask you at all about the suit earlier this week to block Penguin Random House's acquisition of Simon & Schuster. So what, if anything, can you tell us about that, which sits in your section and is an exciting update?
So that's right. Our section does have some other commodities we do publishing, obviously, printing, concert ticketing, so we've done the Live Nation stuff. So let me get to the actual suit we filed on Tuesday. So the acquisition of Simon & Schuster by Penguin would have cemented Penguin's position as the largest publisher in the United States, and it would be over twice the size of its nearest rival post-acquisition, particularly in the market for acquiring the rights of manuscripts and books from authors. In that space, it's really the big five that are the most meaningful competitors for authors who want to sell and auction their works. The head-to-head competition between Penguin and Simon & Schuster has really driven up the advances, which are the wages, for the most part, of authors. And without Simon & Schuster as an independent bidder for those rights, authors will be harmed and make less money. Now, what's unique about this case, or let's say unique in the media, is the attention on the monopsony allegation. The division has alleged monopsony cases in the past. Anthem Signo was a recent example where we were concerned about not just downstream but upstream harms as well. This case, we are focusing on harm to authors and creators, but also there will be harm to consumers, because as wages are depressed for authors who want to sell their works, fewer of them can make a living from what they do, and fewer books will be written and then sold to consumers.
And it's interesting, and I'm sure it's one that all of us in the antitrust bar will be keeping an eye on, since it's still early days. But maybe let's bounce back to what you've been doing besides this more recently. What have been some of the key investigations that have been handled by the new section since it was created? What would you think are your proudest achievements of the past year?
So obviously we just mentioned Penguin, which is only just getting going. And I'll stick to just publicly announced deals. At the beginning of our section, we had the Visa Plaid merger challenge. We've also, this has been reported in the news, we're reviewing the proposed acquisition of IHS Markit by S&P Global. And we also had in the past year the bank deal, Huntington Bankshares acquisition of TCF Financial, which was settled. The attorneys and paralegals in our group do an absolute amazing job. So it is hard to pick amongst, our proudest achievements, but I think the proudest achievement is definitely Visa Plaid and blocking that transaction. Visa had a monopoly share, according to our complaint, in the market for online debit transactions. It had about a 70% share. Visa saw Plaid as a threat to its online debit monopoly. It was planning to enter with a new money movement product, which, it seems to have come to fruition. I mean, recent news reports have said that Plaid is starting to enter that market and is marketing its services to help banks move money for their customers. By blocking the deal, we ensured Plaid stayed independent and had the incentive and ability to attempt to challenge Visa and provide new competition to that market.
Well, I'm glad that you mentioned Visa Plaid, which obviously has been one of the biggest cases in the fintech sector within the past couple of years. And I wonder, it's helpful to hear from you a bit about the specifics of that case, but could you say a bit more about why the division thought it was important to bring that case, and what does that say, if anything, about your future enforcement priorities?
Sure. So I think there are kind of two answers to that. One, why it was important in this market on the facts, and then secondly, why it's important for antitrust policy. So on the facts, I mentioned Visa had a 70% market share in debit. To put that in context, in the year before the pandemic, debit networks processed over $1 trillion of card-not-present transactions. That was in 2019, and that was, of course, before the pandemic led to this growth of online sales. It's a huge part of our economy. And there's kind of an unhidden tax on all purchases that are made with debit cards. It's paid by merchants and it's paid by all of us. So merchants, to absorb those costs that they pay for processing transactions, have to make it up somehow, and it is reflected in the cost of the things we buy. So it is hugely important to the U.S. economy, and anything we can do to prevent a monopolist from taking out a nascent competitor who might be a future threat is important in that space, because entry barriers are very high, and any entry is welcome to help bring the benefits not just to merchants but also consumers of competition and new products and new services. From a policy perspective, it shows that the division is focused on killer acquisitions, that we're not going to shy away from challenging transactions where the facts present themselves in the right way, where a dominant firm is trying to take out a nascent competitor before they really eat into the monopolist or the dominant player's share. It just shows we are focused on that and will remain focused on that.
Yeah, and that nascent competition point obviously is one that Visa Plaid has been getting a lot of attention, not just for that case itself, but as part of a broader trend of competition authorities all over the place focusing on nascent acquisition. It's not just you guys at the division, but the EC and the CMA are looking at this a lot as well. And I'm curious, to what extent do you perceive the Antitrust Division to be aligned with the EC and the CMA and other regulators around the world on those issues? Are you all kind of coordinated and pursuing those together, or is it just something that's come up more organically where everyone's on the same train?
So I can't really say what's behind the scenes in terms of conversations, but based on press reports, I do think those agencies are aligned. Ourselves, the CMA and DG Comp, we're aligned in our focus on killer acquisitions. I don't think that's surprising. That doesn't necessarily mean we can come to the same conclusions in every case, in every transaction that presents themselves, because the facts might be different in different jurisdictions. Obviously, in Europe, Visa Plaid was not challenged. They looked at it and they had a different set of facts over there, and it doesn't show a lack of alignment. It's just we each look at the facts as they are in our own jurisdictions. But I do think there is alignment on the focus on killer acquisitions.
Okay. No, that's really interesting to hear, and I think probably consistent with what as practitioners we've been seeing from you all over the world in the recent months and years. But maybe let's turn our attention back to the U.S., where obviously financial services and banking sectors are one of the heavily regulated sectors in the U.S. economy, and I'm curious whether we're talking about the FRB, the CFTC, the SEC, any others of the alphabet soup of regulators in the banking sector. Can you just talk a little bit about how your section is interacting with those sector-specific regulators in your investigation?
Sure. Within our section, there are particular experts on different issues who keep the relationship with a given other regulator. So we have an attorney who is wonderful about keeping up relationships in the banking area. So she works with the OCC, the FRB, and the FDIC in reviewing banking transactions. We have other attorneys who manage our relationship with the SEC or the FRB on different topics, or the CFPB, and we have resident experts who keep up those relationships and keep up those conversations. Now, how we interact with them, on what topics we interact, we do talk to them about perhaps upcoming regulations, and you have seen probably that we have filed comments in different rulemaking proceedings, including this last summer in an FRB rulemaking proceeding. So we do comment on regulations. We also coordinate on parallel investigations, and we also just kind of keep up the tabs on new things that are going on and just have informal conversations to share learning. Of course, it's, coming from a prosecution agency, we're always a little stymied in those conversations because we have to keep confidential the information we have. So often it's a one-way street of communications.
Got it. Well, maybe let's take a step back and I'll ask you a couple questions, not about what you're doing with the section right now, but just more about your career and how you think about it, because you've obviously had a really interesting and long career doing a lot of different things at the division. And I wonder, a lot of people listening to this podcast are, maybe younger antitrust lawyers who are just starting out. And it's clear that it's a really exciting time right now to be an antitrust lawyer, whichever side of the bar you're on. But, looking back at your career, what advice would you give to someone who's just a few years out, just starting down this path of antitrust?
Sure. So I actually think antitrust is just an exciting career path for an attorney, because of the different commodities, that you get to bring an antitrust framework to many different factual situations and many different industries, and it's just exciting. I think for young attorneys, it is just to get as many experiences as possible across a broad range of commodities, which is something at the agencies you can do, not just DOJ, but also the FTC. When you come to the agency, you do move around the buildings. You do get to try different commodities, get to work on different things all the time. As I mentioned earlier, change is kind of constant at the division in that respect. My own career, I've kind of bounced around. I actually started in the section under a different name that I'm now the chief of. But I had experiences in the telecom section, as you mentioned, the front office, and have been just very lucky to have had experiences on all these different commodities and just try out everything. And I think for a junior attorney, that's important, to try your hand in mergers, try your hand in non-mergers, try your hand in different industries, and just take opportunities.
Yeah, it's certainly great advice. And speaking of all this, kind of constant change, you've also been at the division for, I think, 18 years. You've had a variety of roles. And over that time, you've worked through a number of administration changes. And it does feel, I think, sitting on the private plaintiff side, that there's a lot of momentum behind increased antitrust enforcement coming out of the Biden administration. A lot of companies are very focused on this, worried about this. And I'm curious, from sitting inside the government, if this transition has felt different to you than any that you've lived through previously, or if this feels more like the kind of usual Republican-Democratic swing, or how you've experienced it.
Well, I've been, as you mentioned, I've been through a number of transitions. None of them have been exactly the same. There is obviously lots of talk about transitions between different administrations. To be honest, that's not just the biggest change. I mean, very often at the division, different AAGs, even within an administration, will have different sets of priorities and will take the division in a different direction. So in that sense, the change at the presidential point is not always the most important, although it's obviously important. I mean, this administration's senior leadership has, even though we don't have a confirmed AAG yet as we are recording this podcast, but who knows, it could happen any day now, has been really encouraging bolder action in the antitrust space and has been encouraging us to bring cases where the facts present themselves to show there's been a significant lessening of competition. And, as the Penguin-Simon Schuster transaction shows, this administration, we obviously believe there's a harm in the monopsony space, and this administration has encouraged us to bring that case. So I do think this administration is pushing us to take bolder action, but I also want to stress that, at the division, they're great professionals. We have attorneys, paralegals, and economists, and they're always just doing their work, and they're always pushing things forward, regardless of who's in leadership. We just get the work done, and we try to address the priorities of the current administration when they arrive.
Got it. Well, let me, Owen, ask you one more personal question, which is people may have seen in the press that your wife, Thea, who's also had a long career at the division, was recently nominated by President Biden as the Assistant Secretary for Export Administration at the Commerce Division. So congratulations for that. That's very exciting.
Thank you.
And I'm just curious, again, a lot of young lawyers listening to this, people starting their career, but also starting their, adult lives. And, how do you think about, between two people with such great careers, managing life, I understand your life includes 2 kids and these 2 very successful careers. So what should people think about, if you could go back 20 years and tell yourself what to do?
Well, it's a lot of balancing, a lot of running around. And I going back 20 years of what advice I would have given, I'm not exactly sure because I'm still going through it. But the way we manage involves a lot of focus on a color-coded calendar and keeping things, who's doing the kid pickup today, and really focusing on what the next week or 2 weeks look like. So we have some kind of ability to know who's doing what and keeping our lives sane. So it's a lot of focus on making sure we know what's going on.
Yeah. Yep, I think probably every parent would would hear you on the importance of the color-coded calendar. Well, look, Owen, I could probably ask you a million more questions, but it's about time for us to wrap things up. Thank you very much for joining today and for such a great conversation.
And Jen, thank you so much for having me. This has been great.
I also want to thank the antitrust section at the ABA for putting together this episode of Trust and Trade. And of course, thanks to everyone who's listened in. Thanks again, Owen. Thanks again, listeners, and wishing all of you a great week.
We hope you enjoyed this episode of Trust and Trade, brought to you as always by the Antitrust Law Section of the American Bar Association. Now you know that's the T.